Holding a trust vote is necessary to ascertain whether the Council of Ministers headed by the confidence of the House. Continuous existence of that confidence is crucial to the legitimacy and hence survival of the government. It is a matter which can brook no delay, since the authority of the government presided over by the Chief Minister depends on the Council of Ministers continuing to have faith of the legislative body as a collective entity, particularly when the members resign in an expression of lack of faith in the existing government. The convening, exactly what happened here. The fact situation is exactly what happened here. The convening of a floor test is the surest method of assessing the impact of the resignations on the collective will of the House. The consequence of the acceptance of a resignation is to reduce the numerical strength of the House. Until the resignations are accepted, the members who have resigned continue to be reflected in the strength of the House, having regard to the language which has been employed in Article 193B. Whether in the situation such as the present, an elected government is entitled to continue despite the resignations of 22 of its members has a significant bearing on the issue of confidence. Neither the governor nor, for that matter, the court can infringe upon the power of the speaker. Now, the next sentence, next clause is important of that sentence. But the pendency of the proceedings before the speaker cannot be a valid basis to not have the confidence of the House and the government determined by a floor test. Number 27, the disqualification petition was dealt with by this court, the two-judge bench of this court. They extended time. The next day, a floor test was called for the 30th. So, my lord, what prejudice is caused? Particularly the light of this judgment. My lord, then paragraph 81. We have highlighted the above factual scenario only to emphasize that the convening of a trust vote is of crucial importance to affirm the fundamental values of the Constitution, namely abiding by the rules which govern a parliamentary democracy. The fundamental precept of parliamentary democracy is that the government owes collective responsibility to the Legislative Assembly, and as a collective body, the Legislative Assembly is entitled to hold the government to account. The ultimate expression of accountability is the existence of or the lack of confidence in the Council of Ministers. We are therefore unable to accept the submission of Dr. Singhvi that the holding of a trust vote would short-circuit the jurisdiction of the Speaker on a matter of resignation and disqualification. Well, how is this different from the facts of the present case? On 28th, the trust vote was called for. It was held on the 30th. 29th, they challenged it. It was repelled. Rightly so, because this court has repeatedly held that you can't injunct the governor from calling for a floor test or the holding of a floor test. So, Lord, what prejudice is caused to them? Exercise what rights did you disqualify? Till you are actually disqualified, you continue to have the right to vote and perform all functions of a member of a legislative assembly. So, Lord, this one paragraph completely cuts the grass. So, Lord, this is another aspect, the quia timet injunction, and so these are the three aspects. The notice under 179C, which I said was stillborn because they said we don't accept this notice. Didn't have any further consequence. The quia timet injunction was necessitated by a breach of the rules on their part, giving me only 2 days when the Maharashtra Assembly rules, framed as I said under paragraph 8 of the 10th schedule, gives me 7 days. I had to go to court, inter alia for that. Nothing, there was no quia timet injunction, there was no restriction on him. All they were told, this deputy speaker was told, please comply with your own rules, give them the time, that's all. And I was given a protective order because of threats to the life of me and my family members and my other 33 MLAs, at that time 39 MLAs at that time. So, my lord, nothing in this case has at all caused any prejudice, my lord, to the plenary powers of jurisdiction. There is no case for referral in my respectful submission. And my lord, just one more thing. Ultimately, one more factual aspect. On 29th, the Chief Minister voluntarily resigned. His voluntary resignation was not the outcome of all that went before. He took a conscious decision. He knew he had lost the majority. He knew he had lost his majority and therefore he resigned instead of facing a floor test. So the floor test ordered on the 28th and to be held on the 30th, was itself stillborn because the Chief Minister resigned on the 29th night, before the date even of the so-called slaughters. So, my lord, in this factual conspectus, there is absolutely no reason, my lord, because nothing has caused prejudice. My lord, this is, with the greatest respect to my learned friends on the other side, a case built on foundations of clay. There is nothing.
All right, thank you. Anything else, Mr. Jethmalani now?
No, just one last thing on Nabam area. Since your lordship had, well, a little, I'll only deal on that part, and then I'm done.
You've dealt with Nabam area. Your contention is that because the CM resigned, and there was the 27th order of our court does not amount to any injunction on the exercise of powers by the Speaker.
Yes.
Therefore, there was no question of Nabam Rebaya being invoked here.
Well, your lordship only want to know something about the notice period and that part, 181. If you are not, the lordship don't need an argument on that. You know?
No, we are not concerned with that so far as the reference to Nabam Rebaya is.
Yes, that's. I'm deeply obliged. You know, that's all I had to say then.
Yes, Mr. Bhatt.
No, this is only in addition to and without prejudice to what has been stated, so I will not repeat it. My first point, the point is stated like this. The interdict on the Speaker as per Nabam Rebaya is for a very finite, limited period and is needed to ensure the Speaker cannot tilt the voting membership of the House. For this, the analysis I am proposing before your lordships is this. Rule 11 is said
It is 14 days, if you really look.
No, I am saying something else. Please turn over the page, just see this. Kindly turn to page 2, just see my analysis if it appeals to you. On rule 11.
In A, you have said exactly what I said. The interdict is 14 days.
The interdict is 14 days.
After 14 days,
Yes.
that 14-day period, the Speaker cannot curtail by saying that, look, it was for my benefit.
That's correct.
Period is also for the members to gather these.
So the reason I am saying.
After 14 days,
Yes.
the rule says as soon as maybe.
As soon as
He can convene it on the second day.
Correct.
Once leave is granted, he has not more than 7 days.
That's right.
He can convene it on the
Correct.
next day. So essentially, what Nabam means is that for 14 days after the notice to remove is issued to him, he cannot then preside over the motion.
Your lordship.
So the period really, when he is disqualified, we'll say disabled.
Disabled. Is 14 days.
14 and...
Now, just to add to what your lordships have said, in that 14 days, one of the arguments of the other side was, what if a member does not move a resolution after that 14 days? I wanted to take care of that argument.
What is your answer?
Which is why para 2 may be kindly seen. This is the summary of rule 11 of the Maharashtra rules, and the Lok Sabha rules are identical. Please see notes. Now I am placing A to E. The motion to remove a speaker requires a period of at least 14 days. Your lordships have said so. Now B. After the expiry of the period, the notice is read to the assembly by the speaker as soon as may be after the expiry of notice period. At this stage, there is no second notice or resolution contemplated to be moved by the member. Then the speaker requests for 29 members to rise. So I am saying that the member who has moved the resolution cannot delay the voting on the motion or leave being granted at all. Now please see how the speaker is further protected. Lord. Please come to para Roman 4 of my note at page 2 again. Here I have set out rule 45 of the assembly rules. Again Lok Sabha is identical. Please see the rule. Subject to provisions of rule 109, a motion shall not raise a question substantially identical with one on which the House has given a decision in the same session. So you cannot have repeated motions to interdict the speaker or to disable the speaker. So it is only 14 days in the session itself. Now, please see 109, which is the next rule I have quoted. Roman 6. When a resolution has been moved and voted upon, no resolution or amendment raising substantially the same question shall be moved within 1 year from the date of voting upon the earlier resolution. So for 1 year, the speaker has no problem. So it is actually just that 14 days for once in a year at best. If it reaches the stage of voting, and if it does not reach the stage of voting, only 14 days, a member cannot stop it at all. It's outside the hands of the member. Now, kindly see, now I'm just reading for your lordship's convenience, para 7, which is my submission. Thus, if a resolution is moved and voted upon, no resolution dealing with the same question is permitted to be moved within 1 year from the date of voting upon the earlier resolution.
That's the protection, that you can't keep on repeatedly moving that.
So that is one part of it. Now, my lord, now also consider one further argument. Suppose it is moved on the last day of the session.
It lapses.
It immediately lapses under Rule 20. I have said so at Roman 9.
Rule 20 we saw yesterday.
Yes. Now, my lord, I have also quoted for your lordship's convenience identical rules of the Lok Sabha, which say the same thing. Now, Lord, I'll just add to one more point. My second point, Lord, is which has already been argued that by deciding vacancies, because what is happening, the speaker is deciding vacancies and the people who vote for him is total membership minus vacancies. My lord, on reading article 190, which I suppose the lordship would have seen also, apart from 191, 190 of the constitution is vacancies, which refers to a vacancy created by disqualification. And the people who are voting for the speaker or not voting are total membership minus vacancies.
All right.
And lastly, I'll just
Got your
end,
point.
I'll just end with one last point.
Yes.
Just in addition to this, if your lordship, since your lordships have read Navam Rebbe in great detail, your lordship will find that what pervades the reasoning of Justice Mishra particularly is actually constitutional morality as well, which is my point C. So, my lord, at that time, Manoj Narula was the law which he cited. Thereafter, Institute of Delhi, etc. is coming. So, a constitutional functionary, namely the speaker, cannot, my lord, act in a manner which is against the spirit of the constitution.
Thank you.
This is my third.
Thank you, Mr. Bhattacharya. Mr. Manindra Singh.
Well, as a tail ender, a couple of points, only few minutes. Well, there is no need for reference, my lord, is writ large in the existing constitutional scheme, my lord, prior to the 52nd Amendment in 1985 and even thereafter. My lord, your lordship had asked a question yesterday that besides the incorporation of the 10th schedule in the constitution in 102 and 191, 1022 and 191-2, these are the only, why? Because if the 10th schedule has to become a part of the constitution, some provision must incorporate it. Now, my lord, the question asked was why there is no further amendment in the constitution either with regard to 179, 180 or 181. The answer, my lord, is given by your lordship in Nabam itself, and I will just make a humble submission because Justice Narasimha was, my lord, having a doubt about the commencement of the action and conclusion of the action so that the bar applies. Now, my lord, kindly see 179 only for a moment. I have only to read 179 and 3 paragraphs. Your lordship may mark it, my lord. Your lordships have read it, but after reading it the way I want to read it for your lordship's kind consideration, please mark, my lord, 235, para 235, 236 and 237 of Justice Mishra's judgment, my lord. But before that, my lord, I want to show your lordship article 179. And in my humble submission, my lord, the commencement of the bar under 179 of conflict of interest of the speaker, your lordships is provided in this article